Hello. Can we start the session?
Yes.
Good afternoon, all, and we welcome you to the second session of today's faculty development program on the topic innovative and modern teaching methods in legal education. And this session is handled by Dr. Sanjay Bang. I'm honored and privileged to welcome our resource person, respected Dr. Sanjay Bang. Dr. Sanjay Bang is Associate Professor of Law and PG Coordinator and PhD Supervisor at Christ University, Pune, Lavasa campus. He is also a visiting faculty of IAM, Raipur for legal aspects of business and the Indira Institute of Management, Pune for human rights. Prior to Lavasa campus, he was also a part of Central Campus of Christ University, Bangalore for 4 years. He has been 18 years in teaching, and before that, he practiced in Nanded District Court for 1.5 years. He worked with Lal Bahadur Shastri National Academy of Administration for 2 years, where he taught IAS, IPS, and IFS officers, and also taught forest officers at Kundal Forest Academy of Administration for 3 years. He is also a master trainer of Department of Personal Training, Delhi for Right to Information Act and Right to Service Act. He has cleared net in 3 different subjects: law, criminology, and human rights. With most respect, we welcome you, sir, for this session.
Thank you, sir. Thank you so much, sir. Can I start?
Yes, sir.
Thank you, sir. Thank you. Good afternoon, all of you. It's my proud privilege to share my experience with you regarding the teaching pedagogy. I'm thankful to Priscilla and all the staff of Al-Azhar Law College for giving me this opportunity. Now, the topic which is assigned to me is innovation and modern teaching methods in legal education. So before I start, I would like to give some disclaimer, I would say. The presentation which we are using in Christ University, most of them only I have considered. In fact, I know there are around 24 different types of methods which we can use into our classroom. But I'm specifically focusing only on the five methods which widely we use in Christ University. Second thing, I'm not going to discuss the merits and demerits of all these methods, but undoubtedly how we can utilize it in a better manner. That will be my sole focus. And of course, it's a bird view. We can discuss it in detail also later on, but within a span of 2 hours. Possibly, I will try to just cover how we can utilize all these things in our classroom. So before I start, I would like to share this story with all of you. And I know we have gone through this story when we were in the 7th standard. There was a cap seller. He was going from a forest, and because he was excess tired and he slept there. Then monkeys came downside. They picked all the caps and they went away. He was very annoyed, and then finally he threw the caps downside. Means he tried all his level best first to get the caps, but monkeys were not ready to give. Up till this story we all know very well. And then he used a trick, and the trick was, in angry mood, he threw the cap from his head to downside, and all the monkeys did the same thing. And then he collected the caps and he went away happily. But I would like to share the modified part of this story. I'm not sure whether it is authentic or what, but yes, I thought that I can utilize it in my teaching presentation. Thereafter, the grandson of this cap seller, he was going from the same forest and he experienced the same thing. But he was never worried. He was aware that his grandfather had such kind of experience, and he, instead of trying all his other level, he simply threw the cap from his head downside. But this time monkeys, they did not just throw the caps from their head. On the contrary, one of the monkey asked him the question, what do you think? That only your grandfather shared the experience with you? Even our grandfather also shared the experience with us. So it means things are changing rapidly. Whatever I had experienced around 20 years back, the same thing might not be useful to today's kids. And we need to change rapidly. And of course, that is the rule. Change is constant. Uh, in fact, again, before I go to the specific points, one thing which my HOD always used to tell me, that with the passage of time, the intelligence and arrogance, the two things are increasing in the students. I think all of us might have gone through this concept. Undoubtedly, today's kids are much smarter because of the technology and the research capacity which we are developing in them from the very first year of LLB. Most of us haven't studied even in the LLM as well, but they are getting this opportunity, and because of the internship which they are enjoying, they are getting the practical opportunity to test our theoretical knowledge with their experience. So that's why intelligence is there. But unfortunately, with every rose thrown should be there, some students are showing the attitude as well. But we cannot simply say that they are having the attitude and we are not ready to teach them. Anyway, we need to take the entire class together with us. So the methodology which we are adopting in the class, we need to adopt it not only in a proper way, but in a smarter way, so that we can fit all the students into that mode. Now, in fact, we should thank to God that we are in this noble profession of teaching. And there is always a quote that parents are first teachers and teachers are the second parents. So we are getting not only the place of teachers, but the second parents as well. So we need to be committed towards our kids, our students. And at the same time, if we want to see the future of the country, we can see from two angles. First, what kind of education we are providing to the students, and how the students are going to shape it in their future life. We are fortunate that we are getting the opportunity to deal with both of them. And if we have completed our task in a proper manner, probably we are contributing for the development of the country and development for all the human being. So we are lucky, whatever the job the doctors are doing or the soldiers are doing on the border, we are not doing lesser job than them. We are, in fact, we should thankful to the God for this thing. Now, why legal education is important? Of course, all of us are aware about this, but still, I would like to take the gap. What means, in fact, the journey which has started from way back and from 80s and then 90s. First one, it includes the profession which is practiced in the court of law. Then corporate firms. Today, most of the kids are interested to go to the kids to the corporate firms. Then law teaching, law research, and most importantly, in the administrative part as well. And just now, Khan sir had said that I worked with government department with government of India for 2 years, where I taught to IS officers. Yes, we were three faculties in number. Rest of the faculties, like faculties of public administration, faculty of economics, they were only one in number. Means law is most important even to the civil servants. The same thing was there. In fact, I would say my knowledge was much tested in forest department than there, because of I started the things from zero. So law is playing very important role all over the country and all over the world, I would say. And when someone is having the legal knowledge, he will always seek about the equality and so on. Now, but if we compare the journey of today's law profession with the past, we can say around 33 years back, somewhere in 1990s, the main soul of the legal education was to create the good lawyers. I'm sorry, I'm using this term in a very negative way. To create the lawyers. Most of the colleges, they were not even making the attendance as a mandatory pass. Only the students were appearing for the exam. They were writing the exam and getting the degree. So the ultimate aim was just to go to the court and start the practice. But of course, today the vision is changed. That narrower vision had gone down, and legal education is now tested on the practical way. Now, if I follow the statement which is given by Justice Dada Dharmadhikari, what he said, that legal education makes lawyer an expert who pleads for all like the doctors, who prescribes for all like the priest, who preach for all and like the economist, who plan for all. And up till now, we have understood that when we are studying the law, in our first and second year, we have studied some concept from political science, from economics, from management, and so on. It means in law, we are learning all the things. Of course, law is our specialization, but other areas also we have gone through. So it means we need to have little bit knowledge of all this field as well. But what about the legal awareness among the country? When it comes, even though we are following that technical concept that ignorance of law is not excuse, but can we ask ourselves, are we really following this thing we are teaching to our students? I want to share one example, recent example with all of you. I'm not criticizing either to government of India or to that organization, but somewhere it came into my mind that are we really serious in this concept? Around 5 months back or 6 months back, LIC of India, Life Insurance Corporation of India, had introduced the IPO into the Indian market. And accordingly, the share was listed as per the Company Act policy and SEBI's guidelines. Up to that extent, it was fine. But the thing which hurted me, that was before actually launching that IPO, one thing which was actually advertised, that if you purchase the insurance policies, LIC's policy, you will get a specific reservation into the IPO. And means that was one concept. Of course, for employees, you can reserve the share as per the SEBI's norm. Then for employees, you can reserve, and maybe some means I would say institutional shares can be reserved. But offering such thing, I personally feel that it is anti-competitive practice. Section 3 of Indian Competition Act is attracting them. But I want to ask all of you a question. Have you experienced any single case where this was challenged? What our Competition Act Commission is doing? The answer is very much zero. I'm not saying Competition Commission is not doing anything. I mean to say that in that particular case, nothing was done from the Competition Commission, nor a single even the point was raised. It was not only anti-competitive practice. Section 4 was also attracting abuse of dominance. Since it is a high, means I would say the that player which is having the maximum portion of life insurance in India, it was abuse of dominance. Then I just wanted to check that can I test it with existing life insurance companies if they are there in the share market. Then I realized ICICI Life Insurance, HDFC Life Insurance, and SBI Life Insurance. Apart from LIC, these three life insurance only, not other kind of insurance I'm talking here. The other three are there. But when they introduced their IPO, such kind of reservation was not there. So are we serious? Means this is a question we need to ask to ourselves, that was clear violation of section 3 and 4 of the Competition Act. But anyway, the things are there. And specifically in that country where we are saying we are having the strongest Supreme Court of the world, in the language of Justice Krishna here, he only commented that Indian Supreme Court is the strongest Supreme Court of the world. And the counterpart from where we have taken this concept of Supreme Court, if you compare with the American Supreme Court, you will find that the powers which the Supreme Court of the US is having, they are having much less, means that court is having much lesser power than our Supreme Court. And our constitution is defined and delimited, such a vast constitution, but still somewhere something is missing. Now, the importance of legal education, specifically in a democratic society, democratic country like India, it is badly required. But not only legal education is required, it should be taught properly to the upcoming generation. And upcoming generation, even if for 10% it is utilized in a constructive way, probably half of our problems should be sorted out. Now, it should be expected that legal education should not only produce efficient lawyer, but also create law-abiding citizens with human values and rights. We know that everything cannot be just curtailed under the legal jacket. Laws cannot be there for all the time. Some moral values should be taught. And in one of the Marathi movie, I had gone through one of the dialogue, and the dialogue was to teach, means to teach to the educated people. That is the need of this country. In fact, the poor, the rural people and uneducated, they are following law in much better manner than what the urban people or the educated people are doing. So it is actually the high time for us not only to teach them law, but to inculcate the values as well. And that is easily possible, specifically when we are handling this law. Now, as already we talked, that it's a noble profession, specifically when it comes about the law teaching, law practicing. And the globalization has given a wider scope. What was not available before 35 years or so on has made available. And considering all these changes, the Bar Council has also changed itself. Now, if you go through the regulations of 2008, now Bar Council has made it mandatory to have the five internships, practical internship of 28 days, continuous 28 days. That is actually given under this, specifically I have taken this point, that is rules of 2008, schedule 3, rule number 25 to 27. All these are making 5 internships mandatory, so that our kids can go and they can test the theoretical knowledge and they can challenge us in the court. So if they, in the class, if they are challenging us in the class, then we need to be updated. not only in terms of the contents of the subject, but the way in which we deliver that thing. Now, means we can say, means earlier there was one quote, that quote will begin only after the end of class, but the days have gone now. The students are getting going to the quote from very first semester as well. Like last time, one of my student who right now he is in the second semester only. He had gone to High Court, and after coming from his internship, he was talking to me. Then I said, no, it was not the correct choice. Up till now, you haven't studied the constitution of the country. It's a simple, a very few legal subjects. In fact, apart from tort, if I'm not wrong, he did not study any legal subject as well, and still he went there. Somewhere we need to get them in this passion as well. So what Roscoe Pound has described long back, it's a concept of social engineering, but now the social engineering is not only related to local, but it's a global one. And in global one, we need to change ourselves. So what kind of improvement is required? First, we will talk and then we will go to the specific legal methods. First one, it is important in the sense that the role of directing and moderating the social change, forming an inexorable part of the society. uh, what kind of impact we can play on the in the society, that we need to analyze, and accordingly we need to plan our teaching. Such education must be important with proper teaching methods, so that real essence of the subject is known. If just for the sake, if I'm reading the bare act of the CRPC, and if I say 436, it is talking about the bailable offense, 437 non-bailable offense, it won't make the sense. I'm not carrying the proper things in a proper way. So teachers are the one who shapes the character, caliber, and future of an individual. Undoubtedly, today it's a technology-based era. Our students are using the technology, YouTube, number of lectures are available there. But still, we cannot ignore this fact that the way in which we are teaching them, still the impact and the technology have not replaced us. Thankfully, we are still there. Even though technology has not replaced us, but we need to change ourselves. So what kind of thing? When we talk about the legal education, we need to talk few things like skills of interpretation. Without interpretation, law is like a vacuum only. It cannot operate. Then most importantly, the communication. In court, not only the content or the interpretation is required, but the way in which you express, to communicate, that is equally important. Research. Research is equally important. Then in what context, I can share one example here. In my past institute, Sangli, where one of my colleague was selected for the post of library assistant, because of mistake of one of the authority from Sangli district collector. Sangli is in a district in Maharashtra. The advertisement was printed like you must have the graduation and 1 month certificate, whereas it should be 1 year, and it was not certificate, it should be diploma. But advertisement was published in that way. Then finally the applications were called, the people filled the applications, and then finally oral was taken for that post, and three candidates were finalized. Means post was one, but three on the basis of first, second, third was finalized. She was on the first number. She joined that. Second candidate who came to know that she doesn't have 1 year's experience, whereas this post requires 1 year's experience, where she is having only 1 month's experience. He challenged that in the MAT, Maharashtra Administrative Tribunal, and he got the decision from his side. Then she went to Bombay High Court. The unfortunate part is the concerned advocate in Bombay High Court, when he raised the matter in the court, obviously we cannot appeal to the Bombay High Court. We simply can show that some of the fundamental rights or the natural justice process is violated. Then only we can knock the door of the High Court if we are not satisfied with the state tribunal, specifically state administrative tribunal. When I saw that the entire petition which he filed in Bombay High Court, the matter was like that. I'm girl, consider it in sympathetic way. I'm the only bread earner. Article 14, 15, everything was referred there. But these points were raised there. You cannot expect this kind of sympathetical ground. In fact, she lost the case in Bombay High Court. And since the Chief Justice was sitting in that particular case, no question of review was possible. Then we went to Supreme Court. In Supreme Court, one of my students from Christ only, He's practicing there. I referred this matter to him. He worked in such a wonderful way. He was in a position to show that such incidences have happened in Jharkhand, Bihar, even in Uttar Pradesh. And he was about to convince to the Supreme Court that Bombay High Court ignored these points. At the last minute, the Supreme Court asked one question. Undoubtedly, the points are valid one. But whether you showed these points to Bombay High Court, Honorable Bombay High Court, this was the statement which Supreme Court used. The answer which was given was no. The moment he said no, the Supreme Court said one thing, so High Court is not the God who knows all those things. Second thing, since these points were not discussed in the High Court, we are the appellate. We can refer only appeal. And if we refer these problems, it means we are handling the original jurisdiction, which is not with us. And the case was dismissed. So what it means, research is equally important. You cannot plead these grounds like I'm girl or I'm the only bread earner, consider it sympathetically. In fact, research is based. That case, which we should have owned into the court, we lost that because of less research skill ability. Then problem solving, drafting analysis, all these things are validly required. Now, the teaching in legal education, it should prepare the student to meet the challenges and dimension of internationalization. Today, we can't think only from the national point of view. The world has become the global village, and not only the law of in our country, but at the same time, we need to think about the other country, exactly what's going over there. If we compare the position of our two neighboring countries, Pakistan and Sri Lanka, what kind of problems they had faced, we all are aware. Why the legal system is failed? Can't we make our student to think critically over those points? So all these things we need to know. But now it is the time we need to analyze. We have given much liability to our students, our kids. At the same time, now we need to think calmly and we need to analyze that undoubtedly we expect the integrity of lawyers, advocates into the court, and we expect their professional commitment as well. But don't we think, can't we think that this commitment should begin from the classroom itself? The way in which I'm teaching in the class, it matters a lot on the students. Because somewhere I have gone through that 25% of the portion of life of a person is shaped by parents, 25% is by teachers, 25% by his peers, and 25% by his own experience. Undoubtedly, a quarter of the part of the life of the student we are feeling. So we need to be very much professional. We need to show our commitment in the classroom itself. Otherwise, the students won't learn anything from us. So undoubtedly, the theories, means if I take the example of all the 5 theories of penology, uh, we cannot skip that part. May not be after 50 years or 100 years also. We cannot replace the same thing. The principle, theories, practice, everything is required. But what about the interpretation? If interpretation is not taught to them, they won't take the thing like reformative theory or preventive theory into the court of law. They need to understand the practical utility of that. And in fact, if we bridge that gap, then probably we are justifying to our profession. And the conventional methods cannot be replaced. But at the same time, what happened before 30 years, same cannot be applicable today. Let me share a few examples with you. And I thought that instead of talking about any other bookish language, whatever my experience was there, that I would like to share with you. The two things. First one, the highest academy of forest department, it is in Dehradun, which is in Uttarakhand, capital city of Uttarakhand. And the entire forest syllabus is finalized from there only. The one experience which I learned there when I went there first year, it was in 2015. When I went there, the forest officers, they were studying the law, but they were unaware that why we are studying the IPC, why we are studying the CRPC, what is evidence. In fact, the interesting fact, they were not able to distinguish between IPC and CRPC. They were asking me, can we raise the matter into the CRPC? It means they were studying the subject without knowing exactly what is the purpose of this thing. And unfortunately, the central wing, that is Forest Academy, Forest Education Academy of Dehradun, it had simply prescribed the syllabus. Today also, you can check on their website. They have simply prescribed the things, but course objective, what would be the outcome of the course? Nothing is specified there. And in such situation, we can't expect that the officers will get to know all those things. Most painful thing which was there to me, and of course in Kerala also you must have experienced the thing, Kerala and all the other participants from different part of the country, the one act which is challenging the forest department from 2008 onwards, that is the Forest Right Act of 2006, which was implemented from 2008 only. In fact, this act is a revolutionary act, I would say. Many challenges are there, but unfortunately it is not even prescribed in the syllabus. Only the Indian Forest Act, Wildlife Protection Act, and Forest Conservation Act, apart from our Indian Penal Code and all those. And can we expect that when they will go into the field, they will be able to sort out this issue? It's quite impossible. And one funny example which I want to share with you, this batch, the batch had gone in 2015, to August 2015. And if I'm not wrong, I received the call in the month of November 2015. And the concerned forest officer, he was asking me a question. He saw a dead body of a panther. He wanted to know me since I taught him CRPC. He asked me, sir, what procedure I should follow. Then I told him, not a problem. You make the Panchanama first. Uh, if any evidence you find there, you collect that and then send the body of the panther for the post-mortem and register the FIR. In fact, in Maharashtra, Forest Department is using the term POR instead of FIR. POR is preliminary offense report. It is in their manual, but technically it is FIR only. So I asked him to file the FIR. Then he narrated a story. He said, sir, even though the dead body of the panther is here, but I can understand, means we can just analyze that the panther is killed by animal and not by human being. And we can see that there is certain incidences are there of fight between panther and the other animal. Then I just analyze that what kind of animal it would be. Since it was in Jalgaon of Maharashtra, lions are not there, tigers are there, or might be elephant, even hyena or other animals are also not there. Then our logic was going towards tiger or towards elephant only. Then he told me that I can find some footprints of tiger there. So I said, not a problem, send the body to post-mortem, wait for the doctor's report, until that time file the FIR. Then he asked me a question, of course, that hurted me. But then I realized that somewhere either I might be short or that Dehradun Academy was short. He asked me, okay, no problem, sir. I will file the FIR against Tiger. Now, in FIR, you cannot file, you need not to file FIR against someone else. It's only preliminary information. You have to test that, number one. Second thing, of course, that actus reus and mens rea, I don't want to talk on all those aspects, but human being is required. You cannot file FIR against tiger. That was a common sense. But if you don't teach them what is the outcome of this subject or why I am teaching you this subject, these are the things which are bound to happen. And this person, he cleared the civil service exam of the state government of Maharashtra. But that was the question which was asked to me. Thankfully, now we have changed. We are adopting a course plan. And we can say course plan is just like the blueprint which we use when we are teaching. I mean, when we are constructing a home, I mean, constructing a particular house, what will be the structure of this house? We are finalizing it much earlier. And the same thing we are doing into the course. We can give some certain guidelines that now means today's kids are very smart. Knowingly or unknowingly, they will use the mobile in the class, and definitely it will distract our attention. So we can make the class policy there. We can tell them that these are the particular units which I'm going to consider in this particular time, and so on. Not necessarily that you will be able to 100% follow the course plan. With the passage of time, you can change that as well, considering the base. For example, in Christ University, in the course plan of contract 2, for indemnity, 2 lectures are given only. It is impossible to cover indemnity in 2 lectures. In fact, few of the students who have not proper knowledge of contract 1, first 2 lectures you need to talk only on contract 1. Then only you can make them with the flow, and then only you can go to the indemnity. There are certain practical questions. So that's completely fine. But at least this plan, if it is there in our mind, we can think and we can go accordingly. So good course plan must enable the students to apply their knowledge and not just the production. this is what told us in LLM. Means when I was student of LLM, that in LLM you need not to just produce the knowledge, you need to apply. But I think the time had changed. It's not the production only, it's not the application only, but it's interpretation and analyzing. And that's what we are doing into the Bloom's taxonomy. One more example, I'm sorry, I'm giving excess example of forest law, but practically I work with them and I thought that I can share this one. I'm sorry if it is excessive. Now, one example I want to share here. Many of my forest officers, today also when they call me, they are asking me the question, sir, can we apply IPC? Why not? Why not? Section 2 IPC is talking over that. And one more point is there, means judges many times ask them. Thank you, sir. Thank you so much. In fact, judges are asking them the question: if you are having your special law like Wildlife Protection Act or Indian Forest Act, why you are applying IPC? You cannot stop someone else from applying IPC unless the special law is prohibiting that. And neither the Indian Forest Act nor the Wildlife Protection Act are prohibiting them. And at the same time, what we need to tell that the concept of investigation, which is given in the CRPC, and if the magistrate is allowing, anyone can investigate. The doctors are doing the same thing in the medical negligence case. They are not the police inspector, but still they are applying the means they are following the part of investigation. So unless we tell them, means again I will go to the Indian Penal Code here. In what Indian Penal Code is saying, if we see the preamble, it is applicable to all India and all Indians. That's it. I think the one line, all India and all Indians, it will require 2 lectures for you to explain them that in what way this Indian Penal Code will be applicable over there. It, yes. Means the forest of, I request you if you could mute yourself.
Kindly unmute your microphones. Sorry, mute your microphones.
Thank you, thank you. So now, if they know, means many times they are hesitating to talk before the judicial officer that why we are applying the that particular law. Let me just give an example. Now, Wildlife Protection Act has divided the animals into different 6 categories. And if you refer to Schedule 4, Schedule 3, I'm sorry, Schedule 3 or Schedule 5, you will find the punishment is only 1 year. And in 1 year, not only the trial will change, the investigation part will change as per 468 of the CRPC. We are having one section 429 IPC. If we link that, it will the punishment under 429 is for 5 years. And if it is 5 years, warrant trial and rest of the things can be initiated there. For investigation also, you need not to restrict. You can file the charge sheet. Means in their case, of course, it is the complaint even after 3 years, not a problem. So it's not only the section, but the procedural part of CRPC will also get changed. Same thing is applicable in the CPC as well, if we refer the limitation and so on. But the problem which now coming out from the forest department, I will go to the lecture method. But before that, I want to show my pain to all of you. In previous few slides, we talked about the interpretation. Interpretation means unless interpretation is there, law is not proper and law will work in a vacuum. And the pain which I'm actually trying to show you, right from National Law School, Bangalore, to any other college, any other central university, state university, private university, any college also. Unfortunately, the General Clauses Act of 1899 is not part of the syllabus. Just refer that it's not there. And if you refer the term includes and means, again it will be difficult. How you will means analyze that. Interpretation cannot be learned in 1 or 2 days. It should be a part of continuous teaching. Again, I will give one example and then specifically I will switch to the lecture methods. This example again I'm sharing from the forest only. One of my forest officer, he was actually in a problem. What problem was there? Some bulls entered into the reserve forest area. He seized the bulls. He put them into that particular cage, and then, as expected, the owner of the bulls, he came there. He was simply begging, but he did not accept the request. And then he said, if you want to take back your bulls, you pay this much of fine, and then you can take the bulls from us. But for some reason, he did not come. He went to the court and he complained there that forest officers have stolen my bulls and they are not ready to give me and they are asking the bribe from me. You can raise any allegation. Who is going to stop you? But anyway, the court had sent the summons to my officer. He went there. He was quite sure that my case is very strong and definitely I will defend it into the court. Then the question which was asked to my officer, are you authorized to seize the bulls? He said, yes, I'm authorized to seize that. Then the question which was asked to him, where it is mentioned. In fact, just before 2 months, he came to the academy. He was ACF, Assistant Conservator of Forest. In our language, we can say he is equivalent to police inspector. So he came to the academy where I was teaching. And I told him one thing, that if you don't find any answer, you can say Indian Forest Act. Indian Forest Act, you will find each and everything there. He said, sir, it is written in Indian Forest Act. Then I only taught him that whatever the act you are referring, either it is forest law, IPC, or any other like Right to Information Act as well, first understand section 2. Some people call it like definitional part, but it's not definition only, it's interpretation clause. You will understand exactly what it means. So I only told him that it is given in Indian Forest Act and you should refer first the section 2. Then he was very confident, I think extra confident, that was not required there. He said, sir, it is written in Indian Forest Act. The judicial officer asked him, show me where it is written. Then he picked the book of Indian Forest Act. Fortunately, the definition of cattle is given in section 2 clause A only. And the definition was, please all of you pay your full attention. Definition is cattle includes camel, horse, elephant, sheep, full stop. He was surprised to see that no cow, no bull, or no buffalo, nothing else. He was shocked. Then he said, sir, it is not given in Indian Forest Act, but it is given in Cattle Trespass Act. Can you allow me to show you Cattle Trespass Act? The magistrate said, okay, not a problem. You can show me the Cattle Trespass Act. But Cattle Trespass Act, we don't use like the Indian Forest Act. So he asked his forest officer, his junior, to get the Cattle Trespass Act from around 8-9 kilometers. He came in the month of June, July with that Cattle Trespass Act. And he opened the definition of cattle, means cattle there in Cattle Trespass Act. And this time it was more painful for him. The definition which was given as per Indian Forest Act. So no scope was left now. Then the judicial officer asked him the question, if you want to use Cattle Trespass Act or Indian Forest Act or any other act, I'm giving you 2 hours time. Within 2 hours, show me that you can seize the bulls properly. Otherwise, I will decide what I am supposed to decide. Then he said, no, sir, you can decide. Not a problem. And I will follow the same, what you are directing. Then the judicial officer scolded him like anything. He said that you are a government officer. Be sensible. Don't increase your work and ours as well. And the other person was asked to take the bulls without paying any fine. He immediately came out. He called me. He was very angry, quite considerable, but I'm still not sure whether on the definition of that cattle or whether it was on me. I taught him that Indian Forest Act or so on. Fortunately, I was not in the class, so I picked the phone. He even did not tell me, he even did not wish me like hello or so on. He directly asked me the question, sir, whether bull is cattle or not. I answered, yes, bulls are cattle. Why you are asking me this question? He asked me, now he took the position of judicial officer. He asked me the question, sir, where it is written? I said, Indian Forest Act. He said, sir, no, it is not written in the Indian Forest Act. Probably I was also overconfident. I told him, you look carefully. It is given in Indian Forest Act. He told me, sir, you look it carefully. It's not given there. Considering his confidence, I took a back step and I said, okay, I will go through and then I will call you. Then I opened the book of Indian Forest Act and this was the definition. Cattle includes. Then again I called him. I asked him the question, sir, what's went wrong with you? What's the problem? It's given there. He told me, sir, where it is written, only 4 animals are shown. Then, since he was not from law background, we can't expect that much of interpretation from him. But I asked him the question, whether the government pleader was there or not. His answer was, yes, he was there, but he was a mute spectator. Please understand, this term includes, it's inclusive. Inclusive. It's not restricted up to these 4 animals. For that, it should be means, cattle means. If the definition would be cattle means, then these 4 animals could have been there. But includes is inclusive, and as per the case, we need to include that. This thing I learned that I should have told them that in this way we need to tell them. But please ask yourself this question: are we teaching the General Clauses Act, which is important part, even if it is not prescribed in the syllabus, but we can make it all in, at least in CRPC and CPC, transfer of property, in these subjects, at least we can teach, even in the Indian Penal Code as well. We can make it as an integral part. Now I will go to the all 5 methods which I'm supposed to talk today. The first method, that is lecture method. Undoubtedly, today also, no one has replaced us. Lecture method means somewhere on the T-shirt of a student, it was mentioned full knowledge without college. I asked him what does it mean. He said, no sir, just I wore this T-shirt like anything. Then I said, this might be applicable before 30 years, but now today you need to, if you want to compete with the real world, then you cannot use such kind of thing. And lecture means, even though the thing, the world is changed, the methodology change, everything is changed, but lecture method is not yet changed. And I don't think for next 30 years it will be changed. But we need to change few things. Unless we become outdated, we need to change ourselves. Just again, one example I will give here. While teaching the Criminal Procedure Code of 1973, we need to link it with Indian Penal Code of 1860, and at the same time, we need to link it with with Criminal Procedure Code of 1898 as well. Many of the things we have copied from there only. And what about the criminal manual? Manuals we are ignoring. The rules we never teach in the class. Of course, everything cannot become the part of the syllabus. But if we try to teach them with the rules, some rules I will discuss in upcoming slides. But if we teach them such kind of subjects like CPC or CRPC with the rules, it will be easy for them to apply their existing knowledge and to test when they are going into the court, either in the form of practice or maybe in the form of their internship as well. And the claim which always the people used to make against us, that whatever was taught in the college, whatever was taught in the university, was completely different than what we are following in the real court. It is because we never link the criminal manual. This is the time when we have to think that rules cannot be ignored. Now, if the students are able to understand this intellectual consistency, then they will be able to reason that they can link this particular rules along with the act, and they can come out with the practical approach. And rationality, that we can teach them through the lecture method only, either the case study method or the role play method. They will analyze from their own point of view, but this rationality undoubtedly we can teach them in this case lecture method only, since we are getting the opportunity to see them face to face. All of us have experienced that problem when the COVID was there and everything was online. We could not see them, and because of online, most of the time students, if they are not interested, they were going apart. That was the problematic thing. But now in classroom, we need to engage them, we need to teach them in a rational way. And not only the rational way, we need to teach them from practical point of view, from emotional, not only from the emotional point of view. We cannot keep the emotions away. But if emotions are controlling us, then obviously we need to think that whether we are really able to, means whether we would be really able to give the justice to the society they are expecting. Today, if just means if anything goes wrong from the legislature, anything goes wrong from the executive, anything goes wrong from media as well, the people feel that judiciary is there, and we are playing, means not only as a faculty member, since we are training the future judges and advocates, we are playing a very important role, and we need to teach them from all this practical point of view. Few things I would like to share you here. One, it's I was going through the interview of AP Singh, who was advocate in the Nirbhaya's case for all those four culprits. One interview, it's still available on YouTube. You can check it later on. That interview was taken by Anjana Om Kashyap, who is famous anchor of Aaj Tak news channel. That interview is for 44 minutes. 44 minutes. And Anjana Om Kashyap was shouting upon AP Singh like he's the one only who had effected that crime. Simply, he was doing a job. He was simply doing a job. We cannot consider only from the emotions point of view. And for 44 minutes, you please check. It is my humble request to all of you just to check that. She was asking the same question in a different way. Had Nirbhaya would be your daughter, what you would have done? Why? Why? What about that curative petition which came in 2002? There was no question. What is this curative petition? If the mercy petition is rejected, why this curative petition has been applied by these culprits, and that too one by one? If the offense was committed jointly, then why they are using misutilizing this concept? No way, no way. It was not. It was asked only the thing. If she would be your daughter, what would be your step? It means emotional. And in fact, the common public was also allowed to raise their concern. And interestingly, except one person, I still remember, except one person who raised the issue, he is advocate and he is doing his job. Let him do his job. Except that one comment, everyone was asking him the same question which Anjana Kashyap was asking. It means, and then I realized that one person was advocate. One person was advocate. So emotional aspects can't control us. And at the same time, we should be able to think rationally. I would like to take you to that example of Hyderabad rape case, when that veterinary doctor was raped by the four or five people, I don't remember, four people if I'm not wrong. And immediately when the Nirbhaya case was in discussion, later on it was shown that these four culprits were taken to that place where this incidents happened. And when they were taken there, all of them were trying to abscond from there. They were trying to run from there, and police to stop them used the force, and unfortunately they died in that incident. All the four at the same time, doesn't it create some sort of suspicion? When the bodies of these four were taken back to Hyderabad, I still remember the Hyderabadi ladies. They tied the Rakhi on the hands of police. They tied the Rakhi on the hands of police. Just imagine all these four would have run away from the police custody, means from the control of police. What would be the position? They would have cursed these Hyderabadi police only. Thing is, people are there, they will express their opinion. But when it comes about law, we need to interpret it not from emotions point of view, but from practical point of view. Few examples I would like to discuss here. Not only the legislature or so on. This example from CRPC again I would like to share. This is case of Daulat Ram and others versus state of Haryana. Now, this case is regarding the cancellation of bail, whether the bail can be cancelled or not. When I taught CRPC, I used to talk about this particular case. And in this case, the Supreme Court had given the judgment. Please see the wordings which the Supreme Court had used. Very cogent and overwhelming circumstances are necessary for cancellation of bail. It means you must be a literature expert. You must have completed your MA literature or at least BA literature before understanding these kind of judgments. Cogent, overwhelming, what is that? These are the subjective terms. What is overwhelming for you may not be for me. It means court is giving the decision but not the judgment. This should have been brought into the notice of the kids in the lecture method properly, so that this interpretation skill can be properly developed among them. One point I would like to add here, that is this author, Mortimer J. Alder. Mortimer J. Alder, he had written a book, How to Read a Book. And one quote which I identified useful for this lecture, I have copied from his book only. A lecture has been well described as the process whereby the notes of the teacher become the notes of student without passing through the minds of either. This is a very painful thing. It means the notes are becoming the notes of the student But if it is not passing from the mind of the teacher to the student, then it is of no use. So this was the way in which the expert like Alder, they were criticizing the lecture method. But today, by using the modern tools, we can make the lecture method in a wonderful way. Of course, in today's era, when two things are important, one is the technology. We need to use the technology. If we don't know, we need to learn that. And second thing is the research. When we are entering into the class, and if we are using these two tools, definitely our lecture will be at a different level. And apart from that, some basic psychological points also we need to understand. This point I would like to discuss with you. First one, in a group of students, maybe 10% students will be there who are smart enough, they are very fast, they will understand when you are teaching there, maybe because of their interest, maybe because of their attention level, or whatever the reason might be. They are in the position to grab the subject in a very short time, 10%. But majority of the student, 80% of the students, they require the second explanation. And a second explanation, we cannot teach the subject 2 or 3 times, but at least means we can develop the habit that if the lecture is of 50 minutes, 5 minutes if we are taking the attendance, remaining 45 minutes are there. 40 minutes we can teach, and the last 5 minutes we can remind that whatever we taught today, so that it will give means it will address to 80% of the student. And if not 80%, maybe 50% of the students will be with us. And in the next day, when some students were missing the previous day's class, if we revise the same thing within 5 minutes, again, for those students who were attending yesterday, it will be again a revision for them, which will fix this point into their mind. And those who missed the point yesterday, they can explain, means they can understand it in a proper way. And of course, there are last 10% students who require not only your special attention, but of course with special consideration. Maybe they are mischievous in the class. Maybe sometimes their behavior is also inappropriate, but we need to understand them in a different way. And that's what I'm trying to follow in the Lavasa campus as well as in the central campus, both were. And if we call them, if we are reaching to their level in an empathetical way, probably they will open up and we can understand their problems in a proper way. Now, second method after lecture method, I would like to talk. That is research informed method, research based method, we can say. Now, in the lecture method, what I told that two things, that is technology and the research. These are like integral part of our life, not as a teacher as well, everywhere also. We need to follow this system now. Without these two tools, we cannot survive as well. And being teacher, if we are utilizing this research method in the class, I experienced the wonder in the class. Wonder means it was really super experience which I had taken. But of course, one limitation is there. And that one limitation is that you can utilize this method only into the senior classes. Maybe fourth year, fifth year, or in LLM classes, we can use. The junior students, they cannot come at par with this method. So we can utilize it only into the higher class. Now, some examples I would like to share. Uh, in Bangalore campus, when I was part of Bangalore campus and I was teaching them the penology, once I took them to the central prison there in Bangalore. And of course, while students were taking a round, I was talking to the prisoner, means I was talking to the head of that prison, and I asked him, sir, what kind of rules we are following here? And what are the rules which are there? Can I know? Then he told me that, yes, sir, we can see, you can see this Karnataka Prison Manual of 1974. Karnataka Prison Manual of 1974 is there. The time was very less, only 1 hour was there, but still I had gone through some of the provisions of Karnataka Manual. Few points are there, which of course appealed me and touched me, but one such point I would like to share with you. Please think about it. According to the Karnataka Prison Manual, Karnataka Prison Rules of 1974, one point is there that seven inmates can use one toilet as per the number of inmates in that prison. So it means if there are 70 inmates, 10 toilets should be there. 10 toilets should be there so that 7 can use one. And state has to take into consideration, if the number of inmates are increased, you need to increase the toilets accordingly. Now, please understand, I'm sharing the example of Bangalore. And though my it means I had carried a research as well thereafter, after coming back from the prison, and I took the help of two of my final year students who had opted penology as their subject into elective, and I carried that research in Bangalore and in Belgaum, the two major cities into the state. And then I observed in both of the cities, the common thing is 74 inmates were using one toilet. And this example, this research I carried in 2019, before the year of COVID. Where is 74 number? And I'm sorry to discuss all those things into the class, but in the morning time, when everyone is having this natural call, and if he has to wait there, undoubtedly, it will affect on his body. It will affect on his body, and this is medically proved as well. And in such situation, if we are talking about prison reformation, yoga, pranayam, this thing, that thing, will it work unless we are providing the basic policies to them? And I don't think this is the picture of Karnataka only. All those states where the prison manuals are older. Of course, after coming back to Maharashtra, and after joining Lavasa campus, I thought to have a look over the Maharashtra situation. But thankfully now, Maharashtra has changed the prison manual in 2016 only. So accordingly, up till now, many of the things are properly covered. So it is the high time. They need to change it accordingly. And if we bring all those things into our teaching, even if it is senior class like 5th year or the LLM class, they will listen to you like anything. They will appreciate, not directly, but indirectly, they will appreciate the efforts you have taken for preparation of this class. Your research is talking, you need not to talk. And this method has given me a wonderful result. One more example I would like to share with you. That is, after this Delhi gang rape case, that is Nirbhaya's case, a demand was there from all over the country that for the offense of rape also, death penalty should be there. And accordingly, we amended that criminal law, means criminal law amendment took place of 2013, and death penalty has been uh, inserted into the death rape offense as well. Of course, there are certain limitations, but it is there now. Now, if we compare with our counterpart, Pakistan, the reason is now they are using Pakistan Penal Code, but earlier it was same Indian Penal Code. Most of the sections are same. And if you refer their section 376, the death penalty is part of Pakistan Penal Code since long. You would be surprised to know. Till 1956, they were using the name Indian Penal Code only. In 1956 only they changed the name only. The rest of the things are, majority of the things are same. But when I compared this point, the death penalty, it was there. It was there since 1956 only. It means, see, the Indian Penal Code was same for both countries, but the implementation was quite different. Up till now, I did not get the opportunity to compare the rape cases between the two countries. Maybe after some time we can talk on that. But the outcome of Delhi gang rape case, that I would like to share with you. Now the question here is, since it's a controversial topic, most debatable topic, whether capital punishment should be there or not. I again don't want to go into the detail, but yes, one experience definitely I can share. In fact, till 2020, till 2020, I was of the opinion that capital punishment should be written. But after 2020, I changed my mind. This is probably the one area where I was a little bit having different opinion that my God in this field, that is Justice Krishna Iyer. Justice Krishna Iyer had once said, capital punishment is crime against criminal. It is crime against criminal, which is very touching. But still, I was thinking that capital punishment should be there. But after staying at home during the time of lockdown, social life was totally cut. We were enjoying the food from home. We were with the parents, means with all our nears and dears. All the entertainment facility was there. Everything was there. But after a particular time, we were thinking that we should go now to our regular job. And we wanted to get rid of that life. All the facilities we were enjoying, but we were expecting to go outside. What kind of problem? these prisoners may face, when nothing, no hope is there. At least we were expecting that in 2021, 2022, maybe we will go outside. So by that time, I thought that most painful form of punishment is life imprisonment and not death penalty. He will get away immediately. Anyway, only my opinion I shared, but here and I want to prove it through the statistical data as well and the research which I carried. Please allow me to show this thing. uh, about death penalty we already talked, but yes, we want to ask ourselves a question whether we want to end the crime or whether we want to end the criminal. Probably the record of National Crime Bureau, it is showing that we simply want to end the criminal and not the crime. Please go through that. From 1909 to 2009, not 99, if I'm not wrong, it was 2000. If I'm wrong, please forgive me. From 2000 to 2009, the rape cases which were reported as per National Crime Record Bureau were 12,772. 12,772 from 2000 to 2009. And please take this figure from 2010 to 2019, within a span of 10 years. After that criminal law amendment took place in 2013, the rape cases which were reported were 23,173, almost double, almost double. Yes, counter argument can be there that maybe reported cases are more in from 2010 to 2019. Might be, but at least we cannot ignore this fact that the people are less bothered about the change which had taken place into the criminal law. Story is not ended here. I would like to take further as well. Please go through the rape cases which were reported in Delhi only. 8,242 from 2014 to 2018. 2014 to 2018 means after that Nirbhaya picture. And out of that 20, let me check that figure, 23,173. It was 8,272 only from one place, that is Delhi. So whether that amendment is justifiable, we need to ask the student so that they can develop their thinking ability. They can think the law from a reasoning point of view. One more example I would like to share you. I think I have given extra example from criminal law. So I thought that I should talk now from the civil law as well. My request to all those teachers who are teaching or who have taught insurance law some time back or who are teaching right now, this one concept, societies are not allowing to procure insurance, life insurance. I'm talking about all form of life insurance, but particularly I'm focusing on life insurance. Societies are not allowing to procure the life insurance. In fact, when the life insurance sector was nationalized in 1956, by that time, only one company, means this corporation, LIC of India, came into picture, and all the societies were prohibited to procure the insurance business. When this amendment took place, 1956, 44 plus this 23 means around 67 years. 67 years have been passed. 67 years. Still, the word society is in existence in Insurance Act of 1938. Most painful part. It is there. It is there. That was the correct time. When you are passing one act, can't we think that whatever the counter effects are there, we need to change there. See, one more example I can give here. After that POXO case, POXO, when it was passed, one amendment was there that if a girl is raped, then in such situation, only the female medical officer will examine that. Yes, in case of urban area, it is good. That's the possible thing. You will find many female medical officers there. But what about the medical officers there at a rural part? According to 163A of IPC, the term which is mentioned, medical officer, not female or male, only medical officer. And now doctors are also smart enough. If you go them there and if you compel them to go for the medical examination, they will say that as per POXO, it is only female medical officer, and as per IPC, medical officer. IPC is a general act and that is a special act. So in case of conflict, special will prevail. I don't want to go for this one. Now we know in such kind of cases, the medical report will play a very important role. So when this POXO Act was amended, I think IPC should have been amended. The same thing about this Insurance Act and the Life Insurance Corporation Act of 1956. Now, uh, another part after this uh, research-based method, I would like to switch to the case analysis method. Now, our method of case analysis is quite different than the what management people are following. Their system is completely different. What we are doing here, we are, say for example, if I'm giving them Keshwan and Bharti versus state of Kerala, then obviously they have to go, they have to analyze the pros and cons, the statutory provision, constitutional provision, undoubtedly in that case only constitutional provision, but statutory provisions in the form of that constitutional amendment of 24-25, all those things we need to consider with them. But before following this method into the class, we need to train them how this case analysis should be followed properly. And we can create hypothetical situation like we used to create in case of moot court or in negotiation competition and so on. Thereby, the students will get the opportunity to learn the statutory provision and of course the judicial approach as well, both things parallelly, and they can come with their counter argument as well, as we have to accept this fact that today's kids are smart enough and they can counter challenges. So thereby it will develop their thinking ability, not only the statutory provision or the judicial approach, but all those things can be actually followed properly, and this will definitely develop the interpreting capacity as well. And later on, if this method is followed properly in the form of group discussion and or maybe in the form of argument as well, we can say that it will work like a wonder. But again, some limitations are there, and that one limitation is there: if the number of students are more, specifically if it is going beyond 40 or 50, then probably controlling the class will be a challengeable task. Half of them won't take the active interest. So in such situation, we can call them in a group. For that, we need to spend some extra time with our students. But definitely, one or two sitting in a semester can make the things a different one. Now, the case study and case analysis method, which I followed in my class when I was teaching the subject Constitution, that I would like to share with you. And I request you also please take this case and you please discuss with your students. This example I'm sharing of 2012. In January 2012, UGC changed the pattern to conduct the NET exam. And from subjective, they changed it to objective. Entire country celebrated the thing like the Diwali. After October, it came in January only. They celebrated like anything. And they thought now NET is like a hot cake. It's a simply matter of going and appearing the exam. In fact, UGC was very much clear. They mentioned that for SC category, 45%, ST category, SC/ST category, I mean, OBC category, 50%, and for general category, it would be 55%. It was mentioned there. Probably the students who were appearing for the NET exam, they did not bother to read the advertise carefully, and simply they saw that it is objective and this is the criteria which is required to get through the NET exam. But the problem was, it was not university exam, it was UGC exam, and it cannot be held at par with our university exam. There was one line I still remember, and based upon that line, I was very confident that something different will come. This I have made in a bold point. This one statement was there, and that statement was, however, the final criteria will be decided by the UGC before declaration of result. However, the final criteria will be decided by the UGC before declaration of result. It means that is the basic thing, that percentage 55-50, whatever we discussed now. You have to qualify that. Minimum you need to qualify that. And beyond that, based upon first 10%, 15%, we will finalize that these are the students who have gone through, means who have cleared the NET exam. But students never bothered to read that. And they appeared for the exam. When the answer key was declared, they calculated the percentage, and accordingly they came to conclusion 60%, 70%. One of my friend who is very much close friend to me, right now he's in Aurangabad National Law School. He in fact on the Facebook mentioned that this time I'm clearing the NET with GRF, possibly with GRF. And the atom bomb was dropped by the UGC on 17th October 2012 when this result was declared. And accordingly, uh, means the criteria went up to 65-67% for the open category, and means same 5% less for OBC and 5% less for the SC/ST category. Students got annoyed. They said that UGC have changed the decision in the last minute, and now they are challenging. Means they are playing the game against us, and they challenge the matter all over the country. Means I still remember, maybe for this one single case against UGC, the petitions under Article 226 or under Article 32, if means I don't exactly know the number, but I can assure that the matter which was challenged before the all high court benches and the Supreme Court, it is probably the highest in number. Unfortunately, the less discussed case, but I'm quite sure that the matter which were filed before the court, they were extreme in number and much bigger than any other matter of national interest. Now, there are certain questions which we need to ask ourselves, and this we can ask to our student as well. First one, not directly, but indirectly, we are following the concept that all the three wings are separate in respective area. As I told in the beginning, that our constitution is defining and delimiting, not only defining, but delimiting the powers of each organ of the state. But still, the strict separation we are not following for sure. And there are certain cases where it was mentioned that incidental encroachment is not allowed. Incidental is essential is not allowed, but incidental is allowed. Essential cannot be allowed, but incidental can be allowed. It means yes, it is there. Now, taking the decision that passing criteria will be 65-67% or so on, it's an executive decision. How can judiciary interfere there? It's a common question. But many people, many students, unfortunately, they had given a false hope to themselves that the matter is pending before the Supreme Court or High Court or so on. Now, when I shared this case with my students, I never expected that any case law which will go for discussion for 3 days, yes, 3 days, and whatever I discuss is not ended here. The real painful problem is beginning now only. Now, if you see, what was the role of Supreme Court there? Don't you think that Supreme Court was quite sure, quite aware that this matter, which is of national importance, has been challenged before all the high courts, before all the benches of High Court, and including Supreme Court? According to me, that was the correct time when Supreme Court should have clubbed all those matters, and Supreme Court should have decided this matter so that this would be a binding precedent either in favor of UGC or against the UGC, anything else, but it will be applicable, binding on all the lower courts. But Supreme Court did nothing. Supreme Court simply allowed the things there. And on another hand, we are saying that the high courts don't have the time, Supreme Court doesn't have the time, and so on. How it would be possible if you don't follow the proper rules? Yes, unfortunately, it's a bitter reality against the Supreme Court of the country. And then on 9th, you can check the history. I'm giving the example from Kerala only. On 9th September 2013, 9th September 2013, Kerala High Court became the first High Court in the country to decide this case. And Kerala High Court criticized the attitude approach taken by the UGC and asked the UGC to declare the fresh results as per the criteria which was finalized in the previous one, that is 50, 45 and 55%. Now, just for a minute, imagine that whatever Kerala High Court had decided, if Uttar Pradesh High Court had taken a different view, if West Bengal High Court had taken a different view, it means Kerala student will pass with 45, 50 or 55% as per the case may be, and Uttar Pradesh student will pass according to the criteria which is set by the High Court of their state. Doesn't it seem something which is not acceptable? I think Supreme Court was the correct authority to handle this case properly. Anyway, again, High Court of Kerala was directed by the Supreme Court of the country for one reason. And Supreme Court said that this matter has been decided by a single judge. this matter has been decided by a single judge. It should be decided by a bench, at least a bench. And then on 11th of September 2013, the matter was again taken by the Kerala High Court. The painful thing is why this guideline was not issued to all the high courts. If you don't want to club the matter, first of all, you should have clubbed that. But if you don't want to club, this guideline should have been initiated initially. Kerala High Court wasted the time for entire 1 year. And on 11th September 2017, when the matter was again taken back by the Kerala High Court for its review, then Supreme Court on 26th, I think I have mentioned somewhere. Yes, here, 26th September, please read it 2013. That's my typo error. It was not 2012, 13. 26th September 2013, Supreme Court had given the decision. And Supreme Court said, since UGC is executive and executives are free to frame their own policy, number one. Number second, it is already given in the advertisement that however the final criteria will be decided by the UGC before declaration of result. So no question of compelling them to publish the fresh results with the criteria which was predefined by the UGC, minimum criteria. Then why you ask Kerala High Court to do all those things? It means you were quite sure that in upcoming next 15 days, the things will be that. A bench was set. It means simply wastage of time by the Supreme Court of the country. I'm sorry, I'm very much straightforward and I'm giving my own pain here that what happened. And as I said, this case was discussed by my student for 3 long days. And now what role Supreme Court should play and all those things was properly discussed. Now, even today also, if I ask them, currently they are in the 4th year. If I ask them about this case or some constitutional power or the powers of the Supreme Court, they are very much confident since they had analyzed this for 3 long days, and every one of them is very comfortable. Now, I use this in contract 2 as well, in law of insurance as well, and the result was wonderful. As already I talked, specifically in health insurance, the claim rejection rate is more. First, I ask them, just follow why it is why it is more in health insurance than the life insurance. You can come with your conclusion. And they came with certain conclusion. And then, of course, I added some supplementary factor. And that one factor is most of the health insurance companies, when they are giving the bill, they are adding this one point. Now, I have highlighted that point, that is other. They are giving the bill with the clause other. Now, if it is for oxygen, it is for ICU, it is for some surgery, that can be settled properly. But what do you mean by other? In other, anything, my food expenses, means even though I'm not the patient, I'm attendant, whether my food expenses is included there, whether my accommodation is included there, or means anything can be added there in the other. And most of the time, the cases rejection rate is more for this one particular thing. So few examples, few case law methods I shared with them, and this time I got the wonderful response from their side. In 3rd year, I taught them constitution. In 4th year, in 7th semester, I taught them law of insurance. So this time my pain, or you can say my effort, was very less. I said, now this particular point we will analyze through the case study method, and I want your active participation. The response which I got from them was wonderful. In fact, few of the points which they added were not even in my mind, and I learned a lot. So class would be interactive, and definitely we are setting the foundation for them, that the way in which they will use into the court, it will be wonderful. Now I will go to the 4th method, last but one method, that is role play. Again, I will say the same thing. This role play method I utilize in contract 2 more time. It was in the form of CIA, which Christ University is following, that is continuous internal assessment. Maybe name is different at your end, but the same thing, like the unit test which we are taking or mid semester we are taking, so that we can just check their performance properly. So in CI3, I asked them to prepare, to go for a video, just create a video which will talk about the concept of contract of guarantee or contract of indemnity as per the case. And the response which I got was wonderful. Priscilla, can you please play the video? I think some audio problem is there, but at least you will
Sure,
get
sir.
the idea.
Sure, sir. We'll
Can
play.
you please play? Yeah.
Sir, can you see this video?
Yes, yes, I can. These two are my students. Priscilla, I request you, you can please share this video with all the participants so that
Okay.
right now it is not audible. It's a long video of 8 minutes, around 8 minutes, and I don't want to waste that time. Just simply, I
Okay,
want
sir.
to show these two are my students. One more student is there again. He will become the surety later on, and then other one means yes, yes, you can take over there. He is actually sure it is there. And then after that, that girl who had actually taken the loan, the name of this person who was bank acting like a bank manager, Gaurav was bank manager. Fortunately her name was also Priscilla. Priscilla was acting as a I mean borrower loan. She was taking the loan, and Rajveer was the surety. He is signing right now. And later on, uh, she was not ready to pay, and how the court made him liable. This is what actually is the theme of this video. Thank you, Priscilla.
Okay. Okay.
Now they took a little bit extra time, but well in advance I told them that this is actually the way in which I want this video, and four of them were involved there. The other one became the judge later on, and she decided the case. So four of them were involved in the form of this group. Means, and I think one or two other were also there. They were not directly participating, but they were helping for creation of this video. And when it came about the class presentation, all of them six came together and they explained whatever the basic concepts they understood from the contract of guarantee. And that was really wonderful experience. Today also I remember, means if I'm not wrong, all the 8 or 9 videos of contract 2 are with me. How my student actually innovated that idea. So if we allow them to follow this role play method, they will be at a active mode, not on the passive mode. Generally, when it comes about the lecture method, the first method which we discuss, uh, we also know very well, and it was taught to me in DOPT when I was part of Lal Bahadur Shastri Academy. Fortunately, I got the opportunity to go and study with DOPT, Department of Personal Training, which is the authority of Government of India for their government servants. And what was told to me that if you take the lecture of 1 hour, for first 20 minutes, their attention will be very high. It will be very high. And then it will be shifted. Second thing, means if you teach continuously for 50 minutes, definitely they will not be so active, and their receptive mode, means in the language of mobile, I would say, it will be off. They will not be in a position to receive all those things. So whatever you are teaching, even if your efforts are 100% fine, for example, if I think I have talked this much of CRPC or this is the case, but if they are not in the receptive mode, what else? If I have done my best, means better than best, I would say, but if they are not in the receptive mode, all these efforts are waste. So what was told to us, that either you teach them first, you ask them to write few things, you ask them the question, shuffle them so that they will be active. After all, what is the basic purpose of all these things? The simple thing is they need to be active. They need to be participant in the class. And that is high, means the percentage is very, very high when it actually comes about the role play method. And the result, as I said, is wonderful. And but the thing is, if we are asking them, since we can utilize their skill, they are much smarter than us in the technology, so they can use this. In fact, even beyond our imagination as well. And it will reduce their classroom assignments, just simply writing the things and so on. So it will be win-win situation for all of us. And specific, like the last part of that video, the concerned girl who became the judge, she was specifically talking about the provisions of guarantee act, that according to this particular section, the you have violated and guarantor is equally liable as a borrower. The same thing I was teaching in the class, but what I observed, that this method had done a wonderful act. Since now we don't have the option like the science students. In science, you are teaching them into the class, you are taking them to the library, some practical assignments are there, so that they can check the theoretical approach with the practical. And that's why it is always said that science is proved. Science is proved. But I think the legal education is not lesser than science. We are also verifying. After all, what do you mean by science? Science is systematic study. That's it. Systematic study can be followed in not only in law or science, it can be followed in any other subject as well. The condition is our approach should be clear. The same thing if we give to our kids, they can do a wonderful job. Now, the case study method will deal with the judicial system in various courts and the practical and real-time experiences. Means what was faced, or how, whether the case was delayed for no reason, what kind of problems are there. So these things easily we can actually teach them so that they will understand the basic thing. So role play, of course, is one of the best method where we can talk about the ratio decidendi or obiter dicta, all those points they can understand. They can develop the interpretation criteria as well. In my presentation, majoritarily, I'm focusing on the interpretation skill. So application of logical thing and so on. Now, when I was teaching this subject, competition law, I had given this example of LIC, that according to me it is a violation of section 3 and section 4 of the Competition Act. And when I talked to the student, LLM student in fact, they were very happy. Their faces were indicating that this case is neither discussed in the CI, means in CCI, I mean, nor in any other court, or it was not even in any paper. But still, I interpreted it from my own point of view. I think they will give you due respect for all those things. Now, case analysis method is widely used. Means it is widely used in the Western countries, but at least in our country, it is at a very initial stage. And we need to understand that we have to incorporate this method properly, just with one limitation, that we need to tell them their role properly. If their roles are identified properly, student will do like a wonder. And in the last minute, we cannot expect. For example, tomorrow is my CI. Let's say, for example, after 10 days, by 20th May, I need all these videos, and I'm asking them on 12th May. They can't do their best. At least 1 month's time we need to give them, so that they will this will develop the creativity habit as well and discuss this legal concepts in a very proper manner. Now I will move towards the last part of my presentation, and the last method, that is the collaborative teaching method. Collaborative teaching method in legal education. If you go through the NAC criteria, this collaborative teaching method has been considered there as one of the parameters to consider to give the marks. In Christ University, what we are following up till now, honestly speaking, we haven't introduced yet with the student. But yes, in collaborative teaching, we two faculties are going into the same class and we are teaching. For example, one of my colleague is there. Her name is Kalyani. Kalyani, I think it's student from there only. Uh, uh, she has completed her PG from Kerala, but exactly from where I need to know. She is teaching the philosophy of law, and there is one concept called the liability. So she had discussed all the liability, but the last part, which was penal liability, the criminal laws liability, she asked me to come and talk about the penal liability. So I went with Kalyani and I spoke on for two lectures about the penal liability, and the students loved that. One of my another colleague, Pratishtha, she was teaching banking laws there. And when I started the practice in Nanded, though my interest, of course, is in criminal law, but my senior was having the matter related to insurance and the banking sector. So forcefully, I took the interest in bank and insurance as well. And whatever the experience I had taken there, I went with Pratishtha. She spoke on the theoretical part which she was supposed to spoke, and I talked the students on the practical problems which we face, what kind of sections I raised there, and other things which we could incorporate into the banking cases when we are pleading before the court. All those things we discuss. And whatever the experience, observation also you can say. When she was talking, I was just approaching, means I was observing the student, what is their reaction, and they were very happy. So that thing also we can do. Means I'm not saying that we are dividing the subject one or two lectures, maximum 3 lecture you can share with your colleague, specifically if he is having the interest, or if he is having the practical experience, he can go and he can talk to the student. And of course it's not the comparison between the two faculties. Many time maybe because of some sort of insecurity, we may not allow the other faculty to talk on our subject. That's quite natural as well. Being human, these kinds of feelings are but natural. But specifically we need to tell the concerned person that these are the things which you are supposed to talk on, and we need to be there. It doesn't mean that when he or she will go into the class, I will come out after taking the attendance. I need to be there. So this system we are following in Christ University for past 2 years, at least in Lavasa campus. I joined in 2021 year. So since that time we are following, and this time also I had gone with many of my colleagues for this teaching collaboration. But basic purpose is not, means this method obviously you can use there, so that student will get the expertise of that particular faculty. But what I mean here, we have to utilize this method for the students. And that method is, we need to club one, or means a group of students we need to form, maybe 2-3 students. We need not to pick more than that, maximum 3. And we need to tell them in advance that this is the subject which you are going to talk here. And to assist them, we can ask them to pick 7 students. So overall 10 students are there, the group of 10 students is there, and only 3 of them are coming on the stage and they are talking about the particular example. For example, if I'm picking the topic of arrest, I'm asking to 3 students that you can go and you can means you will come here and you will teach, but you can take the help for research, for PPT preparation, or for any other thing, or for briefing also, with a group of 7 students. And obviously it is not the thing that he's going to teach arrest and I'm skipping that part. Not at all. I'm also having, means in fact I'm having the upper hand over him. I'm not escaping from my liability to teach arrest. I'm going to teach, but I'm allowing that particular group of 10 students to speak there. And in rest of the time, maybe in 1 or 2 lecture, I can wind up the part of arrest. For example, in my course plan, I had given 10 lectures to arrest. If I'm not wrong, 10 lectures I had given to arrest topic. And the student, 2 or 3 groups, arrest of course is a wide topic. So that arrest topic was also divided among a group of 2 or 3, means 30 students I picked, and I asked them that this is the thing which you are supposed to do here. And for 6 days, they were presenting on their own. I was there. I was also adding the point wherever it was required. And then last 4 days, I utilized. It means I'm not compromising with my lecture. I'm not compromising with the content as well. Many of the things which the students could not actually pass this message to their colleagues, means their classmates. I did that. So it means this particular group, they will be very much clear on the topic of bail. The same thing we can do, but always there is one question. It should not be in a mechanical format. If it turns into mechanical format, the participation of the student will be for the sake of participation. Maybe these 3 are presenting and rest of the students are focusing on their own area. That won't sort out the purpose, and in fact I would say it will kill the very purpose of the teaching as well. So there should be some incentive. Then what kind of incentive? That is, again, if you are following the continuous internal assessment system, we can say that the third assessment will be like that only. I am reserving this much of mark for you, so that their activation means their participation will be active and not only for the sake of completion of the role only. So this thing we can actually do. That would be one added advantage. They will be very happy that they need not to prepare and again write the paper only, so that the faculty will assess and so on. It will reduce their burden as well. And believe me, in this collaborative teaching method as well, the students have done wonderful job. In fact, honestly speaking, few of the things when they were presenting on the CRPC, specifically last week when I talked on transfer, revision and review topic for 396 to 406. All those topic, all the sections when I discussed, one of the student Ankita, she was actually leading the group, and she actually spoke on some of the points. And believe me, few of the points which were not there in my mind, she brought all those points into my notice. It means student will become active. Now, one limitation which we are supposed to follow. In fact, I would say two limitations. First limitation, it should not be in the form of mechanical way. Mechanical way in the sense that you have to reserve some mark for class participation. Class participation in the sense, if means for example, I'm assessing them out of 20. 15 marks will I can give for all these things, but 5 marks I will reserve when they will sit there as a student and how they are responding to their classmates. 5 marks I'm reserving for that, and we need to be transparent from that. First one, if it is well defined, transparent, structured and uniform. 4 words I'm using. First one, well defined, transparent, structured and uniform. They won't come with the claim that you have given 4 marks to him and 3 marks to me. But all these 4 things we need to develop. And means they should know their role and their participation should not be mechanical. So if they are aware that for my participation and my discussion as well, I will be given the marks, then they will take definitely active question. Some points we can reserve even for question session. For example, I can ask randomly to someone else, yes, what is the provision of section 436 of CRPC? If I ask in this way, if he doesn't answer, then I'm having the reserve hand that I may cancel the mark, maybe 1 or 2. It should not be too painful, like I'm cutting all the 5 marks, 1 or 2, so that he will actively participate there. This is one point which we need to understand. Second one is there. I would share this example, maybe a personal example I'm sharing with you, and I don't mind as well to share this one. Uh, this was in 2020 when I was in Central Campus. I was teaching by that time contract second, and I was class teacher to second year BAB. I was class teacher, second year BAB. I had taken one morning class. It was 10:30's class, and then because of once one faculty was absent, so I was asked to go and take the class in the same, I mean, in my class, that BAB. I went there. It was the last hour of the day. And generally, the tendency of the student is they won't digest the faculty for the second or third time. And again, it was a last hour of the day. So a few of them told me, sir, can we discuss with you some other thing apart from contract act? So I thought, yes, it's a better opportunity for me also to understand my students. And I asked them, why not? We can talk. Don't worry, I'm not going to teach. We can talk it. I don't have any problem. Just give me a minute, please. So I said, not a problem. We can talk on this. Then the CR of the class, she stood and she said, sir, we do respect you. We respect the system which you are following into Christ University, that is CIA. That is continuous internal assessment. But I hope, sir, you agree with me, that continuous internal assessment is important, but not at the cost of teaching. I did not understand what she actually meant. I asked her, would you please elaborate exactly what you want to say? Then she told me, without telling the name of the faculty, that one of the faculty from CI2, that is mid-semester, from mid-semester onwards, she is taking the presentation from all the students. Every student is presenting for 45 minutes. The faculty told in the class, I have reserved 5 minutes for attendance, 5 minutes for shouting on you. How can we use that? Why I will shout on you unnecessarily? Or I have to prepare in my mind that I'm going to shout on you without any reason. And rest of the 40 minutes you have to present before me. 40 minutes? And those second year kids, they don't know the communication skill. We haven't taught them. And it cannot be taught in the classroom only, even if it might be one of the subject for BBA student, management student. Means BBA, LLB, I mean. But unless they use it, it will be very difficult. Undoubtedly, for your continuous internal assessment, you can have the presentation. It will develop their communication skill. It will develop their research ability. It will develop their stage daring, everything. 100 out of 80 marks I'm giving. But 40 minutes, and that too at the cost of subject. That subject was transfer of property or property law. The students were completely zero in that class, that subject. And they asked me this question. It was 11th March 2020. I still remember that day. And the classes were on the, means we were on the just virtue of completing the classes by 15th of March. Then I asked them, you have taken excess time. If the things are going from January, you should have told me earlier. Now, even if I go to HOD or to the dean of the college, means to the university, what they are going to do now? You should have told me all those things. And then from 15th, means in fact, before 15th March, that COVID and all other situation took place, means scenario started, and their exam was delayed. Fortunately, they got the time as well. Then I had given them the study material for transfer of property, which I did not teach. So what I mean to say, undoubtedly, students' involvement is essential. That we can easily achieve, either through your collaborative teaching, role play, or case analysis as well. But not at the cost of teaching. Teaching, they are 100%, not if 100%, 90%, 80%. They are relying on us today as well. Technology has not replaced us. We are fortunate. We are fortunate. In fact, many other things are outdated now. Just imagine, means how many of you are using the normal watch? Titan, their research department is worried now. Everyone is using the smartwatch. Already our phones, smartphones have killed many things. Thankfully, we haven't become the smart, means we are not watch or we are not the phone, and our existence is still there in the field. Not, I won't use the word market, but we are still in the field. But it is possible if we follow all these new changes into our teaching. That's number one. Second thing, certain code of conduct, ethics we have to follow. And what that girl, only around 18, 19-year-old kid, what she told me, that CI is important, continuous internal assessment is important, but not at the cost of teaching. Means painful message she had given to me. And those things we are supposed to follow. And then I will come to the last point, since Khan sir has turned the video. It means it was a warning to me that wind up now, time is over. So I will wind up, sir, don't worry. Before that only. Now, this method will eradicate the fear from their mind. They will come with the faculty on the stage. They will talk, and it would be like a informal discussion also we could have with them. Whatever the practical problems we could not sort out in the classroom, it can be sorted out in personal one-to-one discussion as well. And this we can utilize in a wonderful way. So I'm going to the last slide now. Concluding remark, a competent class of faculty is the foundation for the progress of legal education. Means if their foundation is strong enough, then constructing the building is not difficult. Sir, I don't know, means I don't have the authority, but still I would request one thing to all other college and all other faculties who are participating from the different colleges or universities. For your first year, please give some experienced faculty. I don't mean that the juniors cannot teach to the first year. First of all, the foundation, if it is built strongly in the first year, it will be easy for them to understand and learn the things properly. Second thing, maybe a commercial approach I'm giving here. These are our brand ambassadors, and these are the person they will tell to the upcoming student. Yes, in this college, the faculties are experienced. They teach really well. If you take the example of third or fourth year, whatever the hard efforts you are doing, they will talk negatively only. That's it. Maybe they have affected by the system. They don't like few things or so on. But for the first year, if you give at least a balance of new teacher and the experienced teacher, it will definitely work like wonder. And their foundation means we can set the foundation only in the first year only. Without them, the future of legal education is blank. Now, teachers are an integral part of universities, which give a platform for developing legal academia. Now, our job is not limited up to teaching, and of course, the NAC has increased huge burden upon all of us. All of us have gone through that experience, and not only NAC. In fact, three different authorities are regulating us. That is NAC, UGC, and the Bar Council. And sometimes to satisfying them, we are even going beyond our role. And I have developed one quote on my own. I haven't copied it from anywhere else. When NAC visited our campus in 2022, October 2022, from August to 2022 October, I think I was going to home by 9:30, 10, like that. And the point means the quote which I developed on that time, हम पढ़ाते भी है, means even though this is my primary job, हम पढ़ाते भी है means we are teaching as well. Apart from teaching means I forgot that I'm a teacher and the primary job is to teach. It means we have taken the different role, and legal education requires all those things. So teaching profession requires undoubtedly knowledge that cannot be compromised. Spend at least 3 hours or 4 hours for the reading. Initially, when the role of the teacher was very much limited to teach, by that time what used to happen, 8 hours we were supposed to be in the college, but only 3 lectures. What does it mean? 3 lectures with 8 hours preparation, with extra 5 hours preparation. So we need to develop the content, no challenge, no replacement to that. Ability to express, how we are expressing the thing, that matters a lot. So, and of course, a positive means we can say not only expressing ability, we can say the class compose desire to teach. I should be an active teacher and not the passive teacher. If I teach on if I sit in the chair, and if I'm teaching, and means I'm least bothered what the students are doing, then it will be difficult. My request to all the teachers, please read two books. One is deep work and other one is hyper focus. Fortunately, I have gone through these two books recently, and these two books have been written somewhere in 2013-14. Now, as per that book, today not only our kids, but we are also distracted. We are also distracted. Means our mobile is the strongest source. Means if a message is coming, if it is in the on mode, and if I'm teaching, if it just blink in my pocket, I will disturb. I cannot focus properly. Hyper focus and deep work. Both books are talking the same thing, but with different and wonderful experience. And specifically when it comes about our upcoming generation, it is much serious than us. Means my HOD Somu sir, he always used to talk in Christ University. Three things matter for the student. One is their attendance, second one is their life, and third one is their mobile. If you ask them that which one you are ready to give me, they will hesitate to give you. They cannot come to one particular conclusion. I think at least the staff of Al Azhar College, you can talk to Priscilla, ask her that what she would have given if any of the three would have been asked. You can say. So this time their attract means diversion is extreme at extreme level. So unless we are active, how can we learn that what they are using, whether it is they are using the mobile, they are listening to me or not? So we need to be very much firm in that manner, and we need to be active teacher and not the passive teacher. Desire to teach and interest in the profession. Yes, honestly speaking, whatever we are doing, either it is teaching, it is advocacy, or as a student, We need to spend seriously 8 hours of the day for that particular thing, so that I can be called as a professional by someone else. Here I'm interested in stock market. Good, that's fine. But when I'm teaching, if I'm just checking where the Sensex is going or Nifty is going, it means for that Sensex or Nifty, I'm compromising with my primary job. So I need to be professional. Now, undoubtedly, in the globalization, the number of changes which are taking place, we can't stop. In fact, if we try to stop, we will be very surely out from the market. So we need to be part of that. What we can do. This one quote I have taken from the book Hyper Focus only. Please understand, and it is equally applicable to our profession. Let us keep our doors and windows open for all the winds to come in. Let us keep our doors and windows open for all the winds to come in, and at the same time to keep our feet firm from being swept away. And at the same time to keep our feet firm from being swept away. So we need to adopt the changes. We can't stop the changes. We have to accept few changes in our teaching methodology. We can use it into our classroom and just see the wonder how it works. So the last slide that I will go, that is, thank you so much for giving me this opportunity, and thank you so much for tolerating me for 2 hours continuously. In fact, I could not make the lecture interactive because of some limitation. I thought I wanted to cover the entire content. So thank you so much. And again, I would like to give back to the organizer. Thank you.
Dear participants, if you have any doubts, please clear. Okay, I think we can wind up the session, sir.
Okay, then. Thank you. Thank you so much.
Thank you so much, sir, for such a great session. And we are so privileged to have such an eminent person like you to share your knowledge and experience with us.
Thank you so
Thank
much.
you so much, sir. I would also like to thank all our coordinators, participants, and everybody behind this. Thank you, everyone.
Thank you. Thank you so much. Thank you. Can I leave now?
Thank you,
Yes, sir.
sir. Thank
Sure.
you for your session.
Thank you. Thank you, ma'am.
Thank you. Dear participants, tomorrow our session will start at 9 a.m. because that means 1 hour earlier than that of the usual time. Please kindly cooperate and participate. Thank you. You may leave now.